All right, boys and girls, moms and dads, Todd Vandermite back for another edition of Freedom Steel. Former NRA contract lobbyist and Illinois gun law guru. We're going to give you a rundown on some of the gun ban cases that are percolating and developments that have happened with them recently. So let's go to Macon County, the Dan Calkins case. There, the Attorney General has submitted their opening brief, in which they have filed their motion to appeal. And they are asking for the following schedule. Defendants, that's the state's opening brief, is due 3/20. The plaintiff's response brief is due 4/13, April 13th. That would be the day after oral arguments in the Southern case. Oral arguments second week of May. There is no date set. So with that, that'll be interesting because we will have had our oral arguments, and I would wager to say that by the time the Illinois Supreme Court gets to oral arguments, you should see a decision in Duncan, the Cali Magban, should see a decision in Miller, one of the California semi-auto bans, should see a decision in Rhodey, the ammunition background check restrictions, and the Billy Club case out of California. You also have the Bianchi case, which is the Maryland semi-auto ban, which has been argued at the appellate level, and we're waiting on a decision. You also then have Atkinson, which was a case argued in front of the Court of Appeals of the Seventh Circuit on whether or not a nonviolent felon can reclaim their right to keep and bear arms. And with all that, we could have any one or all of those decisions coming down prior to the Illinois Supreme Court taking up the Calkins case. And that doesn't even count if they get the DeVore cases that have been consolidated in there as well. So that's a briefing schedule that I think favors what we're going after. Now, Friday, as you know, the Cook County filed a motion for summary judgment in the Viramontes case. They've drugged their feet for almost, or at least 18 months, not that shy of 2 years. And now they seem to be moving at warp speed in order to get a decision. It seems they want to be up on the Court of Appeal before we get our record built in. So that case is slightly ahead of ours, but we shall see. Sometimes, I believe there's a hearing in that on a status hearing tomorrow that we're going to try to listen in on. And this is after they had asked for at least 4 extensions. One of those extensions was 120 days. So they have filed their motion for summary judgment. They have filed their memorandum of law. They have filed what they are claiming are undisputed facts, and I would sorely contest a lot of their facts. In the Herrera case, this is a case that challenges the Chicago gun ban, their semi-auto ban, the Cook County semi-auto ban, and the state semi-auto ban. There was a motion by Cook County to file an oversized brief of 56 pages, the exact number of pages that were filed in the Viramontes case. So now all of a sudden Cook County is moving at light speed, trying to get anything they can up and ahead of our cases. Then you have in the Keneally case, this is the McHenry County semi-auto ban case filed by State's Attorney Keneally against the state in state court, and the state of Illinois had a motion filed and it was removed to federal court. It is in the Western Division of the Northern District. And in this case, the state has filed a motion for summary judgment on the pleadings. The state's attorney filed his case in chief. The state, unlike all the other cases where they've been asking for more time, they have sat here and they have just gone straight to motion for summary judgment on the pleadings. They are trying to do what they done in other cases and bootstrap and get stuff up in front of. They do not want to argue against our legal team. They do not want to argue against Aaron Murphy and Paul Clement. They do not want to argue against Cooper and Kirk. We have the trifecta of the top three law firms between Michelle and Associates, Clement and Murphy, and Cooper and Kirk handling our cases in Southern Illinois with a judge that is going to let us develop a very good record. That's my sense of all this. That's what I think they want to do. I think that they are now moving to try to get this up there. You'll find, looks like between Cook County and the state, they're using some of the same expert witnesses. I'm going to verify all that, go through all that. So that is a short, nitty-gritty, down and dirty, quick run-through of the federal cases that are kind of hanging out there. Highland Park is in abeyance. They were trying to consolidate. They haven't got there. And we'll see what they're ultimately going to do. But that's the only one that's kind of hanging out there. Naperville is still pending in front of the Court of Appeals. They have not filed the record from below, and we haven't seen a briefing schedule on that. So that covers these semi-auto ban cases here in Illinois and all the latest developments and all that. So as always, guys, please like, subscribe, smash that notification bell. Let all your friends know about our channel. Copy and paste this video and put it up in links. And with all that, as always, frag out.